Okay, so the government tries to finesse that point, but actually it's quite a bit broader than just covering illegal acts. Second, there's an exception for any speech of serious merit, and the government tries to finesse that and say, well, it's really any merit, but serious is actually quite a limit. Third, I think most striking, I just want to tell you that all this, it depicts acts of torture, torturing animals, quote, torture. And the government says it's a real narrow statute, torture, see Webster's Third New International Dictionary, quote, the infliction of intense pain, close quote. So I think this should be of some comfort to the CIA agents that Eric Holder is investigating. I wonder whether the Attorney General and the Solicitor General talked over this definition of torture. Doesn't seem to include extremes of hot and cold, doesn't seem to include, sleep deprivation, things like that. So query whether the Justice Department's on the same page about this question. Thank you.
Thank you. I was watching everyone very closely when Nick described a crush video, and everyone displayed the proper amount of disgust. So you're all clear. Next, we have Gene Schaerr, who works at Winston and Strawn. He's chair of a lot of important committees there, and he can tell you about them if he wants, or you can read about them. He will talk to us about business cases, which we mentioned before, a majority of the court's docket so far.
Well, Nick's comments about the Peekaboo case remind me of the Justice Scalia bubblehead. Have any of you seen that? If you've seen the bubblehead, you'll notice that there's a little statue of a wolf standing next to him. And the reason that wolf is there is because of his dissent in the independent counsel case years ago, a case called Morrison versus Olson that Nick mentioned. And Justice Scalia pointed out in that case that most separation of powers problems come to the court as sheep in wolves' clothing. And he said, but this one comes to us as a wolf. And I'm sure his reaction to the Peekaboo case will be, this one comes to us as a Bengal tiger. And I filed a brief in that case essentially making that point, but in about 30 pages. The Peekaboo case actually is a very important case for businesses, I think, because the ultimate issue there is whether Congress can create a regime in which enormous regulatory power is completely insulated from any political review or any political pressure. And that's one of the reasons that we have the government that we have is so that it will be responsive to the needs and concerns of the people. And if you can put the kind of power within a sub-agency of the SEC, the way Congress set up Peekaboo, then you can put all kinds of other things in similar structures, and imagine, imagine the FCC and the Federal Energy Regulatory Commission and all kinds of other enormously important regulatory agencies that were set up like that to be truly insulated from any political control at all, and you can see why that is more than a wolf. Responding to Bob's question about whether there are themes running through the court's decisions, I don't know that there's a particular theme for this year, but there is a theme running through the court's business decisions for the last 20 years. And that is that basically the court has been moving away from the populism of the Warren and Burger courts and has moved toward what you might call a more business-friendly pragmatism. Gone is the reflexive preference for consumers and tort plaintiffs over business interests, and the preference for smaller businesses over larger ones, and our friends from the NFIB might object to that part of the trend. But anyway, those features of the Warren and Burger courts are gone. And today, even the so-called liberal justices have gotten aboard the train. Justice Breyer, who's a sophisticated economist in his own right and is sort of the champion of judicial pragmatism, clearly understands the importance of a strong business environment to our national health. And with the exception of cases involving alleged sex or race discrimination, I think it's fair to say that none of the sitting justices, at least as of the close of last term, seems to systematically favor the interests of any group over the interests of business. And that just wasn't true 25 years ago. One of the key questions for business this term is whether that trend will hold or will be cast into doubt in some way by the addition of Justice Sotomayor and perhaps another justice. So I'm going to talk about three of the key business cases that are on the court's docket this term. The first is called Bilski versus Dahl. It's going to be argued on November 9th. I like to call this the Patent 101 case for two reasons. One, it involves Section 101 of the Patent Act, interestingly enough. And secondly, it addresses what is probably the most basic issue of patent law, which is what kinds of innovations can be patented. The case arises in the context of a so-called business method patent, which is distinct from an apparatus patent, which is a physical product, and also distinct from a process patent, like a process for making glue from a horse or something like that. And the issue in the case is, how do we distinguish business methods that are patentable from those that are not? That question is obviously important to business generally, since if you're able to get a patent on your particular method of doing business, then all of a sudden you have a huge leg up on your competitors. Here's the background of the case. The patented issue in Bilski claimed a method of hedging commodity risk. So it was a patent on a financial process, essentially. The claimed method was not tied to any machine or technology, but was simply a series of steps for manipulating financial relationships mathematically in order to manage risk. The Patent and Trademark Office rejected the patent as claiming non-patentable subject matter, and the Federal Circuit affirmed. And in its en-banc decision, the Federal Circuit held for the first time that to be patentable, a claimed method, or at least a business method patent, must either be tied to a machine or it must create a transformation of one thing into another state or thing, and hence the name machine or transformation test. Now, the Bilski method was obviously not tied to any particular machine, and the court concluded that merely manipulating abstract legal and financial data was not a transformation. You might ask, well, and I tried to make the case sound as interesting as I could, but you might ask, having heard that explanation, why in the world would the Supreme Court want to wade into this issue anyway? Well, they have in recent years have shown a great interest, in fact, in fundamental questions of patent law, and it seems pretty clear to me that they want to be sure that they put their stamp on fundamental patent law issues rather than kind of leaving that to the Federal Circuit, which, as you know, is the Court of Appeals that's charged by Congress with deciding essentially all patent cases. But of course, the Federal Circuit, like every other appellate court, answers to the U.S. Supreme Court, and the court, I think, has decided that we think patent law is just so important that, at least on fundamental issues, it shouldn't be left to a lower federal court. We really ought to be deciding fundamental patent issues, and I think that's why they took the case. Now, if the many amicus briefs that were filed in the case are any indication, the court is all but certain to reject the Federal Circuit's machine or transformation test, at least as the exclusive test for patentability. There are only two amici. There are about 70 amicus briefs filed in the case, and only two of the amici even ask for affirmance, but even those amici say you shouldn't affirm on the basis of the Federal Circuit's test. So the consensus seems to be that the Federal Circuit has inappropriately cut back on the scope of what kinds of innovations are patentable, and the court is probably going to say that. But patent law for the court really presents an interesting policy dilemma, and that is that if you don't provide enough protection for innovation, you're going to get too little of it from the standpoint of the good of society,